a fiscal impact expert, a real estate expert, a landscaping expert for a D1 variance that amounts to a third permissible use on the lot is just an extensive amount of testimony to address the negative impacts, or perceived, in this case, negative impacts. So again, the positive criteria that I think would be relied on for this application would be, of course, promoting the general welfare. I think it's well established that New Jersey Natural Gas and the continued safe and reliable provision of that to your residents here is important. I think criteria G, to provide sufficient space in appropriate locations. And when I'm using these criteria, the purposes of the land use law identified at 40:55D-2 of the municipal land use law. They're not unique to Holmdel. I didn't make them up. They're right out of the statute. So I think criteria A, criteria G, and criteria M, which talks about an efficient use of the land, would all be applicable to the negative criteria in this application, but also to the positive criteria if we were a non-inherently beneficial use, which I do not believe that. I believe that the SECA test is the appropriate test here for an inherently beneficial use. And the reason I think that you can rely on criteria M and efficient use of the land is because your master plan here has a number of goals and objectives in it. Specifically in the land use goals and objectives, it speaks of providing adequate infrastructure to serve township residences and businesses, but limit the development of growth-inducing infrastructure. So I think the township master plan is definitely supportive of placing structures and facilities like this and providing adequate infrastructure in developed area, which ironically is one of the New Jersey Natural Gas site selection criteria as well. As far as the conservation goals and objectives, protect natural resources to the greatest extent feasible, including woodlands, surface waters, wetlands, groundwater, threatened and endangered species, and habitat areas for plants and wildlife. You have the uncontroverted testimony by our expert air and water quality that we are not going to have a substantial negative impact. And I think the fact that the DEP doesn't even require a permit for that alone is certainly evidentiary that there's just no negative impacts. And the utility goals and objectives talk about balancing utility expansion with the goals for preserving open space, conserving natural resources, and protecting community character. So I think placing this in a zone that actually allows for the use conditionally, I think is certainly consistent with that goal. So taken together, when you weigh the statutory criteria for this application, I think we certainly more than meet our burden of proof. I think that the applicant has put forth a substantial number of proffers and landscaping and items that would ensure that there would be no negative impacts, that if I were a planner certainly advising the board, I think speak directly to the imposition of reasonable conditions and what would be written into a resolution for this type of application. And I am hopeful that the board will approve the application because it is, in my opinion, a needed inherently beneficial use in a zone that your governing body has legislatively already decided public utilities are appropriate and permissible, and we meet all of the conditions that are outlined for that. And there is, again, a noted lack of substantial detriment in this application, in my opinion, from a planning point of view.
I don't have any questions for Ms. Capone.
I'm going to let our board professionals go.
So, that was really fast and long. I am going to, I speak slower, and I'm going to try and touch on a lot of the points that I think are important, and I think some of them need clarification. A lot of times you said if I was the board professional advising, if I was the planning professional advising the board, I would. And in this case, I am. And I believe that this is complicated zoning, and there's a lot of details in here that were not really brought out and brought to the board's attention, and I think it's my role to bring that up. Especially since there's obviously a lot of concern with this application. There's a lot of community present. The board members have expressed a lot of concern, and I want to make sure everyone is absolutely clear on what's permitted, not permitted, what's within the purview of the board, and how they approach this. And if I leave anything out, if I, stray, I look to council to correct me. First thing that I want to point out is the representation that the 3 uses on a lot is not something that,
You're fading, could you
Sorry.
repeat that, please?
the 3 uses on a lot, and it's on its face is on an undersized lot, which was not pointed out, is an intensification of the use of this lot. That was not mentioned or was not pointed out. The issue of the conditional use was also not exactly approached in a way that identified all of the possible interpretations of the conditional use. For section, and I want to make sure that I reference it correctly, under public utilities, under the conditional use standards 30-55.2A, the first condition can be met assuming that the public utility is a direct utility service. Condition 2, I agree, doesn't apply, but condition 3 is a little bit more detailed. And it specifically says repair garages and other industrial related uses of utility companies. Other industrial related uses of utility companies shall also be permitted within the OL1, OL2, and 3, provided they comply with the OL3 district bulk design regulations. So that was not pointed out. There seems to be variances that apply to this from that district. Also, as we go down those conditions, condition number 6 specifically says the design of any structure within 200 feet of a residential zone or use shall be residential in character and shall emulate the style of adjacent residential areas in scale, height, buildings, facade, materials, and general infrastructure. And it doesn't even say the design of any building. It says the design of any structure. So clearly, I think this does not meet this criteria. Does not look like a residential district. It does not look like an office building. It does not look like a farm. So basically, a lot of the concerns that were raised at these meetings speak directly to this. And it speaks directly to protecting the community character, which is also related in the master plan. So I don't think it meets this condition, and I think that needs to be pointed out. So bear with me, because what I'm trying to do is go through the testimony in order as I heard it, and make sure I touch on all the items that were raised. So as far as
Into the microphone, please.
one of the things that was done was to first state that you felt it's inherently beneficial use, and then address how it would be approached if it was, and also if it wasn't. So one of the things that I think one of the things